Okay. Okay, everybody who's on, we're going to start in about a minute promptly. Um, so if you like to keep your video on, love to see smiley faces. Keep yourself on mute. If you want to unmute yourself during the course of the presentation, you're more than welcome to do so and ask a question directly, or you can ask in the chat room, and we hope to get all the questions answered during the from the chat room during the presentation as well. Um, so we're going to start just in a minute. Thank you so much. Okay, so there we go. It is 12 o'clock sharp. Welcome everybody to our November fiduciary, or I should say October Fiduciary Education Forum presentation today. Um, I'm Todd Wohl. I'm the host of the Fiduciary Education Forum in conjunction with our companies at Braun International and Premier Estates. Those of you who may know us know what we do. Those of you who do not, we appraise, broker, and auction real estate and business assets throughout the U.S., Mexico, and the Caribbean markets. Hopefully soon to be Canada in the next couple of months. And we created a fiduciary education forum about 3 years ago, purely to educate all of our friends and associates and people that want to learn about, different topics relevant to our different businesses. And I'm honored to have Kevin Singer, who is our speaker today. Kevin, who our companies have worked with for decades, is truly an expert in his field. I'll let him introduce himself. Kevin, why don't you do that?
I'm Kevin Singer, and I run two different companies. I run Receivership Specialist, which specializes in court-appointed receiverships, partition assignments, provisional director appointments, and then our second company is called The Trustees Group, and we handle professional fiduciary appointments in people's estates and trust. So that's what I do. I've been doing it for 25 years now. Been appointed in over 632 cases in the court system. We have offices throughout California, Arizona, and Nevada. Just recently opened up an office in Denver. Yeah, this is what we do. And
Thank you. So today we're talking about two separate topics, but what we're trying to do for our viewers is intertwine them. The thought for this presentation and for everybody, our website is fiduciaryforum.com. It's on the screen. This presentation, the video version of it, will be up on our video library, as well as the hard copy or the Word version of the presentation will be there as well. And at fiduciaryforum.com, it's a compendium of our previous presentations, of which there are dozens and dozens and dozens. So lots to learn if you like to go there. So my thought was with Kevin was to talk about two different approaches to, again, solving problems. All of our viewers, I believe, are parties that into or have clients that engage them, that have problems, that have resolutions that are needed. And provisional directorship is really, for some people, quite well known, and others not known at all. Partition referee, to me, is uh, one of my favorite solutions to a problem when there are partners that can't agree to disagree. So with that, I think we're going to get started. So Kevin, Um, First off, tell our viewers, what is a provisional director?
Sure, Todd. Uh, First of all, provisional directorships are like soap operas on steroids. Hollywood writers should follow these cases for good content for TV shows and movies. They generally don't happen because everyone is getting along and making sound business decisions. Typically, they happen when there is contention amongst the directors of the board. For example, we had a clothing company, two 50% shareholders. One owner was the designer, and the other had a relationship in Pakistan to manufacture and ship products. The clothes were sold through online sales, and it was a very successful company that was doing well. In fact, it was doing too well and growing too fast. And one of the shareholders decided to do a distribution and buy a Lamborghini. The other shareholder did a distribution to throw a lavish Las Vegas pool party, including using a private jet to fly people in. Well, as the provisional director on this, obviously we had to set up distribution policies and procedures through the board to get control of the finances. So that's just a little taste of some of the things that we deal with in provisional directorships.
Everybody likes to know and hear about the soap operas. Of course, we have many. So
Yeah,
then, with that, what are the situations where a provisional director is brought in?
typically you need a tie-breaking vote, or you need someone on the board with expertise, or you need someone on the board who can raise money, or need to reinsure investors that they retain some decision-making control. And provisional directors can be two types. I mean, they can be done outside the court system, or they can be done, within the court system.
Well, why don't you? I think that would be a good segue. When you talk about within or without the court, when would our viewers think, okay, outside of court, what would be, again, what would be kind of a reason for them to think about you as a provisional director and having this party on the board?
Yeah, I mean, look, if you can do it outside the court system, and save the cost of filing litigation and going through the whole process, then it always makes more sense to try to do it outside of court. And it's easy to engage provisional directors. You can just reach out to them directly, and they can contract with you to be a provisional director. So, but sometimes it just doesn't work out that way, and you have to go through the court system in order to get a provisional director appointed.
So what does that look like, timing wise, if you had to go through the court, uh, give our viewers just a flavor of that, would you?
Yeah, I mean, you're going to have to file a lawsuit, okay, so that the court has jurisdiction over it. Then you're going to have to bring a motion to request that a provisional director be brought in. However, one of the nice things is that the threshold to bring in a provisional director is very low. It doesn't. You don't have to prove that there's theft. You don't have to prove there's mismanagement. All you have to be able to show is that there is that decisions can't be made within the corporation, and there's gridlock. So that's the only thing you have to prove to get a provisional director appointed.
How long would you say it would take to do that, if you had to guess based on your experience?
Well, I mean, it's gonna depend on the court, obviously, and how fast they're hearing motions. Uh, in in a court that's moving very well and can hear their calendar on a 30 days notice motion, you should be able to get it within 30 to 60 days. But many of the courts throughout California are very much backed up, and it's potentially possible that you may not get a hearing date for many months out, and it could be a very prolonged process. Although you always have the right to go into court on a expedited basis and explain that you have some type of emergency.
Mhm. Okay. Then speaking about that and our next question, how do you get a provisional director appointed?
Well, like I said, you have to file a lawsuit, and then after you file the lawsuit, you can bring a motion to have the provisional director
Appointed that way,
appointed.
assuming,
Yeah,
yeah,
and as I said before, it doesn't always have to be done through the
through the
courts.
courts.
Yeah.
And who can be appointed as a provisional director? Is there some sort of qualifications? Define the who part of it.
Yeah. I mean, outside the court, you have a lot more latitude. I mean, pretty much anybody can be appointed as a provisional director outside the court. But if you are going to do an appointment through the court, it has to be an impartial person. It can't be a shareholder. It's not a creditor of the corporation. You can't be related within a third degree of any director of the board. And you can't be related to the judge. So those are the requirements within a court appointment.
Got it. Got it. Otherwise, as you said, anybody, and technically anybody could be appointed outside of court, right?
Yeah.
Yeah,
No
based on
restrictions,
qualifications,
no qualifications. There's no licenses to do it.
right? So let's talk about risks. What are the risks of being appointed a provisional director?
Well, first of all, lawsuits. Lawsuits are the biggest risk. I mean, from investors, beneficiaries, potentially regulators, taxing agencies, owners of the company, vendors, and other companies. It wasn't my case, but I saw a case with shareholders who owned a truck gas station, and the fuel tanks in the ground were leaking, and they leaked into the water tablet. And they were cited by the Environmental Protection Agency for contamination. And I noticed that they also named not only the company, but the directors of the company. I've seen companies get sued, and they also named the board of directors. I've also seen regulators who have levied directors' personal accounts due to a commitment on the licenses to pay taxes. I've even seen levies on directors over real property because they didn't pay certain sales taxes in certain states. So it's a big problem if a company does not have a directors and officers insurance policy or funds to protect you or to protect you from litigation or these types of matters. I mean, most bylaws will say the business is to defend and hold harmless. But if there's no funds in the company to defend, then it becomes a cost that you may have to personally bear. Or if the company goes into bankruptcy or receivership, the receiver or trustee may not want to spend the funds of the corporation to protect the directors, and I don't believe they're required to. Court-appointed provisional director is always a better way to go, because if you're court-appointed, then you're going to have judicial immunity from the courts. So anytime you have a corporation that just doesn't have the financial funds or resources, and you're considering getting involved, make sure it's through a court appointment.
So I guess going to the next question is, how can you avoid risk as a provisional director?
Well, first of all, try to only take appointments with solvent businesses. Check to see if they have directors and officers insurance policy. And if you're going to take it, make sure they name you as an additional insured on the policy. Have your own errors and omissions policy, which covers provisional director work. Definitely research the company, check for lawsuits against the company. Research the other directors that you're going to get involved with, and make sure they're people that you want to be involved with. Make sure they have corporate counsel, and I would interview them to see if they're competent and what litigation they foresee for the company. When you're helping the board make decisions, you want to build consensus from other board members, so everybody's voting in the same direction, or at least trying to. Always have corporate counsel approve actions taken by the board. And I'd always demand in the contracts or the court orders to be able to retain your own personal counsel if necessary, and the company pays for it.
So is there, as being brought in as a provisional director, is it possible to, I guess it's possible for anything, but what are the chances of being indemnified, and how would that stick if you ask for it?
Yeah, I don't think it's a problem. I think both the, if you're doing it outside the courts, I think you're going to have indemnification language and limiting your liability. And even in the courts, you could put those types of things in your court order. But as I said, the dilemma is that indemnification is only as good
As
the financial wherewithal of the corporation.
Understood. So always an important question, Kevin. How are provisional directors compensated?
Usually outside of the court and through the court, usually by hourly rates that they bill.
Okay.
And but I've also seen agreements before where they get shares of stock, and I've even seen percentages of the profits offered to some provisional directors. I'm personally not aware of any regulations on limiting their compensations.
And how long would this directorship last? What is the term?
Some are as simple as 1 or 2 votes, and then they're off on their own, and then some of them last for years. So it's just a function of what they need to break their gridlock, and how quickly that can be accomplished. And if it can be accomplished quickly in a couple of decisions, like who's going to be in charge, who's going to run the company, that board vote, and then from there, they're fine. They're off on their own. And sometimes, it goes on for years, that they need somebody to advise them, guide them, to be that neutral third party whenever they, can't make decisions.
Okay. So what is the role in the sense of selling the business or selling the real estate? How would that occur?
Well, I mean, if they're going that direction, where property needs to be sold, and you have equal shareholders and equal, then the provisional director can be the tie-breaking vote to allow them to move forward. But it's also nice because a lot of times there's such distrust amongst the shareholders, where you have a neutral third party who can go out and get the real estate valued or get the business valued. Um, and I think that creates some credibility, with the parties, to be able to move forward. Or sometimes, we have to do review of the accounting books and records. And I think having, a neutral third party doing it, who doesn't have a dog in the fight, makes it easier for both parties and helps bring their conflicts, to resolution.
So, question, how would the provisional director that's brought in be removed from the position?
Sure. Yeah, well, outside the court system, there's always language in the contract uh, that provides for their ability to terminate you or your ability to terminate them. So it's usually provided for via contract. In the court system and through the court system, it can be accomplished by filing a motion with the court and getting the court to sign off that the provisional director be removed.
Mhm.
Typically, we do it by stipulation. When the responsibility is done of the provisional director, typically all the parties will stipulate it. They'll be
Understood.
removed.
So let's talk about an interesting assignment. An example why, of a case that you were brought in. Why were you brought in? Who were the parties that brought you in? What were the issues, without, of course, mentioning any names of any kind?
Sure, sure. Obviously, I'll change some names and
Sure.
a couple little facts, but the gist of what happened is certainly there. So we had two sisters who had a corporation which owned real estate and ran a home decorating business. And they had leased space in their real estate to a dentist who was married to one of the sisters. And they had multiple other tenants in the building. And one of the sisters had an affair with the other sister's husband,
Oh,
which led to a divorce. And actually, she remarried the other sister. So, anyways, as you can imagine, their relationship has been completely deteriorated. So they can't run their home decorating business together, and each is demanding funds from the customers that they have. So the customers are just confused beyond belief. They can't run the real estate because each is demanding rents from the tenants, and the tenants are confused. Everyone is highly emotionally charged, and they just can't work together. So basically, they need to get a second divorce here. They also need an accounting to equalize distributions each one is taken because they've been doing money grabs with the rents of the property and with customers. So that was a case where we were brought in as a court-appointed provisional director to help lead them through a wind down and dissolution of the corporation and the sale of the real estate. And by having a tie-breaking vote, they were able to make business decisions and close down the business and sell the real estate. And as I mentioned before, since the provisional director is a neutral third party who can communicate with both sisters and can oversee the accounting, do the true ups for the case, and provide distributions, it worked very well. It was also good when we had to evaluate the real estate, that they knew that the provisional director was a neutral party. Do you have time for a second story?
yes, please, go ahead. Got a couple
Okay.
minutes.
Okay. So, second situation, we have a father who runs a very successful trucking company. Okay, the father unfortunately gets Alzheimer's and has to step down as the CEO. Um, Father is a 50% shareholder. He has two brothers who are each 25% shareholders. Uh, since the father is not around, the two brothers are now each fighting for the CEO position of the company. Uh, One brother will hire somebody to work at the company, the other brother will fire them. Both brothers get in verbal and physical confrontations in front of the employees. So the employees feel uncomfortable. Obviously, the company morale is down, and customers are seeing the instability in the company. Both brothers are using the company as their personal piggy banks. And basically, you have a once thriving company is now headed towards bankruptcy. So we were brought in outside the courts as provisional directors to number one, calm the water. And what we did is we interviewed both brothers because we just realized they couldn't work together. And based on our findings that one of the brothers was a better leader for the company, we took a board vote, and he was put in the position as CEO to lead the company. It was also decided that the other brother will not work for the company just to keep the calm, but he'll receive his full wage and benefits. Also, policies were put in place to control the distributions by the board, so everyone stopped using it as their piggy bank. And company got back on track and had a record-breaking year that year and outperformed all their previous year's sales.
So in that example, how long would you say you'd be engaged as
uh,
the
yeah, we've been in now for 3 years because they're having litigation outside of what they hired me to resolve the ownership and management of the company. So that one I'll probably be on, for many years to come, or until their litigation is heard, and it's ultimately the courts make some determinations.
Interesting.
Yeah,
Well, good. What we did for our viewers, these are the actual Kevin, this is the um, was kind enough to have us include the corporate code and the information there. I don't think there's really much to talk about here, Kevin. You said we just wanted to include it, and if for our viewers, they can read it later. As I said, this presentation is at fiduciaryforum.com.
that's just the law for appointing provisional directors, and like I said, it's really kind of concise and to the point. And the biggest issue before the court is, whether there's gridlock, not whether there's been um, theft or mismanagement. You just have to demonstrate that the board is at an impasse because of equal votes.
Okay. So we're now going to move on to partition referee, one of my more favorite topics. And Kevin being, of course, a partition referee as well as a provisional director, I thought was a perfect speaker on the topic here. So, Kevin, for our viewers, why don't you talk about what is a court-appointed partition referee? Let's start with that.
Sure, sure. Well, when parties own real estate and they can't agree what to do with it, uh, there's always the remedy of going to the courts and asking, the courts to appoint a partition referee to basically take over, sometimes manage, sometimes not manage the property, but conduct the sales process for the parties so that it can be done, and then it can be turned from real estate into money, and then money is much more easier to divide. Not that it always goes that direction, because there's other types of partition actions. Just when I get involved, it's typically going that direction. I mean, there is partition in kind, where properties can be divided and partitioned. So there's other ways to do it. But typically when I get involved, the parties that are at an impasse, and they need somebody to kind of be the leader, usually to manage, market, sell, and then help facilitate the distribution of proceeds after that.
So what is the timing to get appointed?
Yeah,
You had to guess.
once again, yeah, I mean, it depends upon the court system and how fast.
Right.
But you're gonna have to you're gonna have to file a lawsuit for partition. Um, I've seen courts handle it two different ways. Sometimes they'll require you to have a trial first, and prove up, the ownership of the property. And then after that process has been completed, they'll entertain appointing a court partition referee. Or on other occasions, I've seen the court, the lawsuit gets filed, and then they allow some type of summary pleading to be filed, where they're requesting that the property be partitioned, and the court makes determinations and moves forward with engaging a court partition referee to step in and take control, manage, operate, and sell the real
So it
estate.
can actually take quite a bit of time.
It could. I mean, sometimes there's circumstances that may justify the court expediting the process, such as the property's in foreclosure, it may be lost in short order. So those might be extenuating circumstances where the court expedites it. But it could be anywhere from 60 days up to, 6 months or so, just to get a partition referee appointed.
Mhm. Okay, good. So we talk about, how is it appointed? You already spoke about that. On the second paragraph, once the parties realize there's no agreement is possible, one can file the lawsuit, as you mentioned, and appoint the referee to sell it. Have you ever been involved in a case, Kevin, that the court has not appointed the partition referee?
Sure. Yeah, I mean, to get to the point of the referee, I mean,
Hmm.
you have to have parties who just are never going to agree on anything. I mean, most parties, when a partition action are filed, they'll get together on their own, and they'll agree, hey, let's hire a real estate agent, let's get this property on the market, let's cooperate, let's get it sold, let's divide the money. So for them to get to me, you typically either have somebody who can't make a business decision, or somebody with psychological issues, most of the time, um, or somebody who's just so financially desolate that, and they're living in the house, that they just have nowhere to go, type of situations. So that's when it typically comes to me.
Okay, good, good. Let's go talk about authority. You want to start with that?
Okay. Yeah, once a court partition referee is appointed, he basically steps in the shoes of all the parties, and it's nice because then you don't have to run around and get everybody's signatures, and you can move forward much more efficiently. But yeah, he has the power to hire real estate agents. Certainly, if we need a lawyer, we have power to often do that. You know, signing purchase agreements, sales agreements, listing agreements, signing deeds. So all those powers we do have as court partition referees. But when we handle these cases, I mean, we like to work cooperatively with the parties and try to get them to make as many decisions as they can make, almost like the provisional director assignments. So if the parties can make decisions on their own, then that's what the court partition referee I support. Where they can't make decisions, I'll often be the tie-breaking vote and help them move forward to be able to get the property sold. Where they both just can't agree on anything, then we just take the lead and we make the decisions for them. And there's a lot of safety checks in this process, because as a court partition referee, you have to first file a report with the parties saying this is going to be our method of sale, and they have an opportunity to object to that. And if they object, we'll typically go in and seek instructions from the court. Any contract that we contract with the buyer is always going to be subject to court approval, and potentially even an overbid hearing if we think it's going to generate more money for the estate.
What would you say, from your experience at least, appointing a partition referee for a business versus real property?
Mhm.
Is there kind of your experience is 50-50, 90-10? What do you see?
Oh, as far as, I mean, most partition actions are for in fact, yeah, almost every partition action that I've done are over real estate.
Real.
Typically, when we're dealing with a business, uh, it involves bringing us in as a court-appointed receiver, to do the sales of the business, through the real estate. So,
Let me ask you, have you ever had an issue, Kevin, where you're appointed as the partition referee, you've gone through the process of sale, you sign the contract as the referee, the property's now in escrow, and then you get a title company that says, "Oh, we don't like what you're doing, we don't like what the orders, we're not providing you with title insurance."
yeah, that
Which of course, as us as brokers and real estate auction specialists, that's our first question. Is
yeah.
title going to provide insurance? So talk about that for a second, would you?
Yeah, I mean, we always try. I mean, whenever we get a new case, the first thing we do is we pull the preliminary title report, and we look at that and we meet with the title company, and we discuss if they're comfortable insuring the sale, because you want to know it up front, not, you don't want to know it at the 23rd hour, right before you're getting ready to close your sale, and then they surprise you and say that they're not comfortable with this anymore, and that really puts you in a bind. Yeah, it's so fascinating with title insurance companies, because we've had ones over the years where, I mean, we've done hundreds of millions of dollars of title insurance with them. I mean, sales and title insurance, and then all of a sudden they don't want to insure our sales anymore. Not because of something that happened to me, maybe something that happened with another receiver or another partition referee. And you look at them and say, God, we've done all these sales together. We've never had a lawsuit. We've never had any problems. But now they have a new underwriter on their team. And
Right.
all of a sudden, everything has changed, overnight. So I try to work with multiple title insurance companies as well. Just so if we do get in that predicament that we can, take it to somebody else. Obviously, before we do that, we try to meet with them. We try to reassure them. A lot of times, if I get my counsel on the phone with their underwriting counsel, they
Mhm.
can speak the same language and they can get the comfort, with the deal. But yeah,
Yeah,
title insurance is always the big unknown in every deal.
well, it is. And, from our perspective, selling the property, we technically are the tail wagging the dog. But yeah, our first line of defense is to look at title. And I think you rightfully said, we've had all kinds of sales with all types of courts and all in almost every state in the country. Um, and and one of our worst cases was with whereby Fidelity decided at the 11th hour they were not going to provide insurance where initially they said they were, and we went down the path with the sale, making those assumptions, and then I don't remember if it was a new underwriter or somebody just decided the winds were blowing differently on Michigan Avenue, and boom, they said we're not doing that. And of course, I think that was an 18 or 19 million dollar motel or hotel. And luckily enough, we were just by pure chance and luck, we knew Fidelity's underwriting group in Jacksonville, Florida, and got a counsel for the sellers and the referee involved directly with the attorneys for Fidelity. And we had to go really high up the food chain, I have to tell you, because it was just door slam, door slam, door slam. And I wasn't going to have anything of it. Um, and they finally agreed. I think there was there, and I don't remember all the issues, but they wanted something tightened up in the order, and the referee, they got it done, and we got it closed. But I tell you, I think that was like maybe 70, 80 days of brain damage after we were under contract. So, I think for all our viewers, today people ask me what are our biggest impediments? It's title insurance and property insurance and how those two are affecting a sale or if it's saleable at all or at what cost. That's the first thing we look at. Um, but let's continue. Steps in a partition sale of real property. Kevin, you want to walk through this real quick?
Sure. I mean, what we always do up front is we get the property valued. I mean, appraisals are pretty cheap for single family homes. So we get them
Yep.
done, we get broker's opinion of value.
Yep.
And the first thing we always do is we sit down with the parties and say, does one want to buy out the other? And the second question is always, do you have the ability? Because so many of them want to do it, but
I
they
don't
don't
have the
have the
ability.
ability. So we always explore that, and hopefully we can settle the case early and we can work ourselves out of a job quickly, and everybody remembers us as adding value and just very honest and straightforward. If that doesn't work out, then as I mentioned, we're required by the partition code to file and serve a recommended method of sale. And what that's going to have in it is it's going to be the referee saying, hey, I got these appraisals, I got these brokers' opinions of value. This is the price that I recommend that we list it for, and this is the way we're going to market it. And here's a copy of the listing agreement. And we typically file it with the court and serve it on both parties. And if nobody objects in 10 days, then we just execute on that plan. And that's in our appointing order. But sometimes you get parties who object, and then you have to file a motion with the court to say, hey, Your Honor, this is how I'm recommending we handle this. and they can file briefs of opposition. Obviously, we try to work it out, and I try to keep it out of the court as much as possible, because if something small can be adjusted and we don't have to go through the court process, we always prefer that. Mediation, settlement, and stipulation. Yeah, I didn't do these bullet points. I'm not sure what they meant by that, or marketing. Oh, yeah, I'm not sure what they meant by mediation, settlement. I think that's what I just covered. Yeah, just talking about how parties can work
Okay.
it out.
So, yeah.
Yeah, then we have to go through a marketing process. Look, we get calls all day long from people who say to us, if you get a new listing, or you get a new partition action, call me up. We're always willing to buy the property. But you have to remember that when a partition referee sells the property, he's going to have to get the judge's approval. And the first thing the judge is going to look at is, how was this property marketed? And, was it done well? Because if you can't make the case to the judge that you did a good job of marketing this property and really exposing it to the market, then they're not going to approve your sale. So it's important. Yeah, obviously stay on your buyer to remove contingencies. You want your sales to move timely. Then, as we talked about, we have to motion the court to confirm the sale, and we need to serve all parties with that. The code does provide for an overbid process. It's really, up to the parties in the court. In certain situations, we've been able to negotiate much higher offers because the buyer was going to have to forego the overbid process. It wasn't going to happen. So the parties agreed to waive the overbid process.
Well, I just want to add something in there. I'm speaking now as a broker, or even in our auction platforms, which Kevin's well familiar.
Yeah.
The overbid process, and we're dealing with this on a pretty large bankruptcy case right now. If we're talking about a residential home, we do everything in our power to push back on allowing the judge or the court to have an overbid process if it's resi. The reason being, it's really simple. Buyers and buyers' agents are not, in most cases, familiar with an overbid process. I don't care what kind of court you're talking about, but generally they're not familiar with it. They're not comfortable with it. They don't know about hiring an attorney. They've gotten their loan approval. They've jumped through all the contingencies, and now they could lose it. And additionally, the time that it takes to get the overbid process, on calendar and then confirmed. So I do everything in our power, unless, of course, it has to be to say, look, the sale process, be it a brokered sale or if it's an auction, there is no reason for an overbid process if you're running a public auction, because a public auction is the overbid process. You can't argue that, and I've never seen a court argue that. But I think it's very important to understand that versus in commercial property, apartment building, a shopping center, an office building, an industrial building, whatever, there you have more sophisticated buyers. The price points in some cases are much higher, which allow the buyer to have an attorney, which afford them the expertise to buy that type of property. So we don't necessarily push back horribly on overbid for commercial. But because we do all this, we try to analyze these situations carefully to make sure the thought is considered by the partition referee, the court, the parties involved. So really what they're doing and what we're trying to do is get the maximum price without inhibiting the buyer pool. If we inhibit the buyer pool, we of course lower the price. Pretty simple. So anyway, just wanted to add that in. Kevin, next.
I just wanted to add, on the
Yeah.
bigger commercial properties, sometimes they don't, the buyers, won't participate if there's a an overbid procedure. But a lot of times we've been able to negotiate around that by providing them a breakup fee.
Right.
So if for some reason they do get overbid, they could, get a very large breakup fee to make it well worth their time. But what we always do is the first bid in the overbid process will cover that breakup fee plus some additional money for the
Right.
estate. So it's just one of the.
Yeah, in bankruptcy is, it's obviously if anybody's on this call with has bankruptcy experience, that's a stalking horse process, and that stalking horse process can be manipulated candidly any which way you want to use it. But Kevin, you're right. The overbidder, the stalking horse, has to be incentivized, but at the same time, uh, there has to be the benefit to the seller for it. So, yeah, you just have to balance that out. Um, for those of you familiar with us, in our WorldBid auction platform for resi or commercial, we essentially use a stalking horse process for every sale that we do. The only difference is we do not incentivize the buyers in dollars for the right to submit a pre-auction offer. We give them the right to submit a pre-auction offer with contingencies and with loan. So they have the right to buy it now at their price and their terms versus buying it at auction, which is an as-is non-contingent sale. So there are a lot of buyers, both commercial and more importantly, resi. We just sold a $6 million home in Florida at auction, and the buyer bought it pre-auction. And their incentive was that they got to buy it at pre-auction because they were able to circumvent the auction itself. So
Right.
again, this is all psychology and strategy, and having somebody like Kevin and his team are going to help you do that. Kevin,
Todd,
on this,
Todd just got a great result for us. We had a big portfolio of apartment building properties up in the Modesto area, up in Northern California. And we were getting very close to some bank foreclosures. So we really had to move them quick before we lost the assets. And he ran a marketing platform and really exceeded our expectations with it. But it was so fascinating because the buyers who had bought the properties at the auction hadn't gone and checked them out. So after they had already committed money to the auction, they realized what they had bought at the auction. And yeah, but it was actually, Todd, I hope you don't mind me sharing this. It was a fascinating story. The guy who bought all these properties at auction flew down to meet with Todd in Los Angeles, and he he told him that look, I didn't get a good deal on these properties. No, and it's my own fault. I didn't do any due diligence on them, but I wanted to build a relationship with you so that if you have future things down the road, that we have the ability to buy more product from you. And I just thought it was a nice story.
no, I appreciate that, Kevin. I wouldn't have even thought about it, but you're right. That is what happened, and now a somewhat regular client. And I think I want to say to our viewers, those who are not familiar with auctioning real estate as an example, it is not, yes, it is auctions can be used in a foreclosure process, an Article 9 process. There are different bankruptcy, 363 sales, but probably 80% of the auctions we do, Kevin, are retail auctions to retail buyers. It is just another tool to find buyers, dangle the carrot, and get them interested now. The average auction timeline is 60 days. And I will tell you, 90% of our buyers, as you just said, alluded to, Kevin, are retail buyers. These are not investors. And again, it depends on what we're auctioning, mind you. If we're auctioning a $10 million home in Wyoming, which we just did, that somebody wants to buy a home in Wyoming, and the auction drove it to them. The auction drove them and created the urgency and the value and the frenzy. That's what an auction does. It's not a distress mechanism of sale. It is purely another way to market. Um,
And
But Kevin, going back to your slide, selecting a referee, you want anything you want to add on this?
it's just it's just good to have somebody who's really experienced and knows how to do this process. Um, the process, I mean, in order to get through this process, the judge really has to believe in the person that he's going to hire to be the court partition referee, because he's ultimately going to work for the judge, and that's who he answers to, or he or she answers to. And so you really have to have experience knowing how to do this. You have to come in with a lot of confidence, knowing that you know the process, because most judges rarely do this. So when it comes before them, they're really looking for a leader and somebody who's going to lead them, lead the parties to the case, and make sure that we move along the process in a very efficient, um, but in a way that's going to maximize the proceeds to the parties in the case. So as you go out there and interview court partition referees, I mean, know them, know their experience, know their backgrounds, um, and yeah, make sure there's somebody that you think can work well with both parties, because these cases go so much easier when you have a partition referee, who's a leader and who also will work with both sides.
Do we have any, I saw we had one chat question from somebody and one of our other viewers answered it, so thank you very much. Does anybody want to unmic themselves? Does they have any questions for Kevin or myself? Don't be shy, embarrassed. Any question's a good one. There's no such thing as a stupid question. If anybody
Yeah,
wants to unmic
this is
themselves.
this is Jonathan Warnick.
Hi,
You
Jonathan,
talked
how are
about how
you?
you bill on an hourly basis, but how do you determine the rates? And sorry to be like go to the jugular on that.
Yeah. I mean, it's typically based upon your resume and your experience. But you also have to look at the size of the company, uh, or the estate, and see if they can handle that type of billing rate. I mean, if they're a Fortune 500 company, they can handle $1,000 billing rates. If it's a small mom and pop types of businesses, I mean, it's going to be much more on the lower end because they're just not going to be able to afford that type of service.
Yeah.
And then as a follow-up question, a lot of times, like I can find out everything on Pacer in terms of the bankruptcy, how much people have charged, what's been paid out, all those things. Are there similar records available to see, like on some notable receivership cases, to see like what were the parameters?
I don't think so. I don't think so. I mean, it's really a determination, of you know what the judge feels comfortable signing off on, for hourly rates, for the court receiver. So um, it's yeah. I mean, we have adjustable rates because we'll take on smaller cases from time to time. So I'll have a lower billing rate, on cases that just can't afford it, and then much bigger cases will have a higher billing rate on.
Yeah. Um, well, look, we're at the top of the hour just about. I just want to tell everybody again, this presentation is recorded. It'll be at the fiduciaryforum.com website that you see in front of you. Our next presentation is early December, talking about insurance, life insurance, how to sell it if it's an asset in an estate, how to figure out how to sell it and how to get the cash for the estate. And then we'll have two great presentations in early January. For anybody who wants to receive updates on FEF, just send us an email. send it to me. Um, and go to fiduciaryforum.com for future for updates on events. And then I want to thank Kevin for taking his time. He's much appreciated. Kind of walk through all of this with everybody and give them options. And on our end, a lot of our work starts as typical appraisals or just kind of advisory and thinking about what is the strategy that might be a value that we can provide, even staying away from, unfortunately, for hiring Kevin. There are things that we offer that may do that and solve the problem if the parties agree. But again, thank you everybody for joining us.
Thank you, everybody. Yep.
Happy Halloween, and we'll see everybody next month. And signing off. Thank you for joining us. Thank you again, Kevin. We sure appreciate it.
You're welcome, Todd. Thanks for including me.
Thanks,
Okay.
Todd. Thanks, Kevin.
Thank you.
Okay.
Thank you, everybody. Thank you so much for participating.
Okay.